Good afternoon, ladies and gentlemen, and welcome to Koranteng Koranteng Legal Advisors webinar today on the theme Navigating the Tightrope of Administrative Compliance under the new Anti-Money Laundering Act. We started 5 minutes after the scheduled time to allow more participants to log in. At this point in time, we have 36 attendees who have joined this webinar. We actually have 122 registered attendees, so hopefully in a few more minutes, we should have them all online. By way of introduction, I am Afua Adubea Koranteng, Managing Partner of Koranteng Koranteng Legal Advisors, a law firm based here in Accra. The practice areas of the firm are banking and finance, capital markets, natural resources, energy, oil and gas, telecom and telecom infrastructure, technology, mergers and acquisitions, labor law, agribusiness, regulatory and compliance, company secretarial, international trade and investment. So we are a commercial firm and that deals in these specific areas. We have here today at this webinar, we are going to go through the theme as we've indicated, and we ask that all attendees jot down questions after each panelist has spoken so that we can answer the questions after the panelist has spoken before we move on to the next panelist. At the end of all three speakers having made their presentations, we can do a general question and answer as we go along. At this point in time, the 122 attendees are made up of various banks. I've noticed in the registration, we have Republic Bank, we have NIB, Omnibisic, ABSA, EcoBank, Societe Generale, EY, we have ZPay, Prudential Bank, Stanbic Bank, Fidelity Bank, GT Bank, Cyrus Oil, CBG Bank, Enterprise Group, and Hollad. A number of registrants did not indicate where they're registering from or which entity they work with, but I believe that we have quite a plethora of attendees here online. Now, why did we decide to adopt this theme or choose this topic? The world on finance right now is going through quite a fast pace of evolution. This is underpinned by technology as seen in cryptocurrencies, for instance, trade as seen in blockchain, globalization as seen in remittances, which has led to multiple layers of money transfer outlets across the world and especially in Africa. There's also the simple necessity as seen in mobile money revolution, especially here in Africa and in Ghana. Now, this evolution has given rise to money laundering and financial crime issues, and also presents a risk to the full utilization of these payment and trading systems. Given these complexities, is the current AML landscape well buffered to mitigate these identified risks? And how far can the new AML law stretch to prevent these systems from becoming conduits for some traction of money laundering? Over 60% of the global money payments occur in sub-Saharan Africa. And Ghana is the fastest growing mobile money market in Africa. And last year we had over 570 billion US dollars mobile money transactions worth. Inward remittances are one of the foremost contributions to Ghana's GDP, and we seem to be readying ourselves for crypto. Now, why did we say a tightrope? We mentioned the tightrope in the theme because the new Anti-Money Laundering Act provides additional duties, administrative checklists, and a heightened duty of care and responsibility for institutions falling under the Act. So now at this point, with that introduction of the theme, I'd like to introduce to you and mention our panelists for this event. We have online Maame Saah Oduro-Frimpong of the Bank of Ghana Financial Stability Department. We have Mr. Kojo Dougan, who's a senior consultant on digital finance and open banking at Kyrios Dougan Inc. We also have Mr. Godwin Kwame Tamakloe, who is a senior manager, compliance AML Risk at MTN MobileMoney. And here at this point, we welcome and thank the panelists for being part of this session today. Now, at this point in time, we would like to share with you some of the key changes in the new Anti-Money Laundering Act before the panelists start to speak and give their presentations. The panelists indicate whether you can see my screen. If you could kindly nod your heads, I'll know that you see the screen properly. Okay. So the Anti-Money Laundering Act 2020, Act 1044, was passed by Parliament and assented to by the President of the Republic in December, 29 December of last year, 2020. It is, the preamble to the act is that it is an act to consolidate the laws relating to the prohibition of money laundering, provide for the establishment of the Financial Intelligence Center, and for other related matters. Now, the act repeals the existing or the previous Anti-Money Laundering Act 2008 and its amendment. And the key thing to note is that for those of you in the industry, you do know that the Bank of Ghana periodically issues various directives to the industry. Now, any orders, directives that have lawfully been made under the previous act remain in force until they are reviewed, cancelled, or withdrawn and terminated by the Bank of Ghana or the relevant institution that gave the directive. So please be mindful of that. Now, the money laundering, the general definition is the illegal process of making large amounts of money generated by a criminal activity such as drug trafficking or terrorist funding appear to have come from a legitimate source. Act 1044 was enacted to fill these loopholes of the previous Anti-Money Laundering Act. So although the changes between the old act and the new one are not so extensive, the point is that it solidifies certain key provisions in this new act, which has taken into consideration other recommendations and international standards. Now, the Financial Intelligence Center under the Act is set up to serve as the administrative and operational backbone and to fight against money laundering. There's a provision in this new Act that the FIC is supposed to receive periodic reports from the relevant institutions that fall under the Act. It also has introduced provisions for board members, so that to be on the board, you have to be a principal state attorney nominated by the Attorney General. In this act, a failure of the board to disclose interest in a matter would lead to the revocation of the position of that board member of the FIC. So that's generally about the FIC and the provisions that the act has introduced to them as the administrative body. Now, we have done a short comparison of the key provision of the Act, which is the definition of what constitutes money laundering. Now, you will notice in this table, which is shown on the screen, that the key difference between the provisions in the old Act and the new Act is that under the new Act, it doesn't only just say that the person commits the act of money laundering if they convert, conceal, disguise, or transfer property, but that it is for the purpose. So the Act goes further to say that that activity is for the purpose, or what they did would be for the purpose of concealing or disguising the illicit origin of the property, or assisting any person who is involved in the commission of the unlawful activity to evade legal consequences of the unlawful activity. So compared to the old Act, you see that this provision goes deeper and imposes a stricter liability. The second leg of the definition also talks about the person concealing or disguising the unlawful origin of the property. Now, under the new one, we talk about you conceal or disguise the true nature, source, location, disposition or ownership of or rights to the property. So once again, the new Act gives more specific provisions for what would constitute money laundering. Similarly, under provision C, you've got a person acquiring, using, or takes possession of property, knowing or suspecting at the time of receipt of the property that the property is or forms part of proceeds of unlawful activity. Now, the key provision here is that you know, knowing or suspecting at the time. So for service providers, for banks, for individuals in various institutions where your alarm bells or your instincts have raised and you think that something wrong may be happening, I would advise that as a result of this provision, you do not ignore that. Do the necessary things that you need to do and take the relevant steps to report your suspicions accordingly. Now, unlawful activity itself, as defined in the old Act, was simply conduct which constitutes a serious offense, financing of a terrorist act, or contravention of a law which occurs after the commencement of the Act. Now, the new Act 1044 actually lists 25 various offenses that would constitute unlawful activity. And these include terrorism, human trafficking, counterfeiting, kidnapping, forgery, corruption and bribery, fraud, tax offenses, environmental crimes such as illegal logging of timber, insider trading, market manipulation, amongst many others. So they're listed actually in the definition section of the Act. So this Act is quite broad. Now, the duties of accountable institutions. Now, accountable institutions are the institutions that fall under the scope of the AML. And these include anyone receiving or making payments, so entities that receive or make payments, whether physically, electronically, insurance companies, lawyers, real estate companies, game of chance as in lotteries. And there's a tall list of accountable institutions in the definition sections of the Act. So you may want to take a look at that in detail. Now, the scope of organizations that are considered as accountable institutions has now included the definition of a virtual asset service provider. Now, the inclusion of such institutions as part of the accountable institutions is in line with the Financial Task Force recommendations. And as Speaker Maame Saah will delve into that. But the inclusion of these institutions, the virtual asset institution, is crucial for considering the emergence and growing popularity of things like blockchain technology, cryptocurrencies, and a relatively deregulated nature and operations of such markets. So the virtual asset provider is defined as any natural or legal person and as a business conducts one or more of the following activities or operations for or on behalf of another natural or legal person. And then it goes into detail with what is considered a virtual asset provider. Now the Act then also delves into, it provides more eager way of securing compliance through the use of sanctions as compared to the old Act. Now the new Act introduces administrative penalties. So from the suspension, revocation of licenses. So for banks, for instance, if you breach the AML Act, your licenses could be suspended or revoked. For other institutions, you could get written warnings, and it gives the Financial Intelligence Center power and discretion to impose penalties on these accountable institutions for failing to comply with the Act. For an individual, the penalties range from 6,000 cedis to 240,000 cedis. And for companies, we're talking between 12,000 cedis to 1.2 million cedis. And that really isn't the limit. Depending on the severity of what has been done, obviously a court of law may impose other fines and imprisonment as relevant. Now, per Section 5 of this new Act, where it is established by a court of competent jurisdiction that property was acquired in contravention of the Act, the property will be confiscated to the state. And the presumption really is that you have acquired unlawful property. And the burden is on you, the person, to indicate that you have legitimately acquired these properties and it wasn't through unlawful activity. Now, a significant thing to note under this new Act is that per Section 44 of the Act, there is no civil, criminal, or administrative action against directors, officers of accountable institutions for breach of other laws, such as data protection laws, when they report that there's been suspicious activity by an individual or entity, provided they reported that in good faith. And in addition, for that person who has been reported to the Financial Intelligence Center for suspicious activity, that person will not be subject to criminal action for money laundering or terrorism in connection with that transaction that is reported in good faith. So provided the transaction is reported in good faith and it is found that there is nothing to worry about, it doesn't automatically lead to the person reported being subject to prosecution. So in conclusion on this short presentation on the new Act, it provides a firm and administrative basis for operation by expanding the duties and powers of supervisory and administrative investigative authorities. The administrative duties of accountable institutions and other related organizations have now been increased to allow a more efficient system of monitoring and effective carrying out of center's duties. So that ends our presentation on the Act. And at this point in time, we will then move on to our first speaker.
Thank you very much, Afua.
Give me a moment, Maame Saah.
All right.
So by way of introduction of our speaker, Maame Saah Oduro-Frimpong has been a legal practitioner for the past 19 years. In this period, she has practiced in areas of litigation, corporate and commercial law. She currently works with the Financial Integrity Office of the Financial Stability Department at the Bank of Ghana, which is responsible for AML and CFT compliance in the banking sector. She presently works on AML CFT related issues as well as fraud in the banking sector. So welcome, Maame Saah.
Thank you very much, Afua. And thank you for having me. A good afternoon to all participants once again. And picking up from where Afua left off, it's imperative for industry players, especially bankers, fintech, present changes in the Act. There are a lot of responsibilities which used to just be by way of, and the enforcement used to be by way of administrative sanctions. And we were relying on Act 930 as a regulatory body to enforce these sanctions. But when you look at the new Act, it's provided for administrative sanctions, and it's also provided for criminal sanctions when a liable entity or person is found culpable. And so the responsibility is increased. So I would like us to, just a moment, I'd like to share my screen.
Maame Saah, you may go ahead.
One moment, please.
Okay.
Should turn it. Okay. Let's see. Yes. One moment. I don't know. Thank you. Okay. So.
Hello? Maame Saah, did you want me to share the screen for you? I could share your presentation. Otherwise, we can move on and take Mr. Dougan's presentation and questions, and then we come back to Maame Saah when she's ready. I think she may be having some technical challenges. Mr. Dougan, is that okay with you?
Yes, that's fine with me.
Great. Okay, so Mr. Kojo Dougan is an experienced business operations and strategy executive with a passion for skills development, mentoring, and a demonstrated history of working in the information and technology services industry. He is a certified solutions provider with 20 years experience in developing iterations and strategizing technology solutions for the private sector, and is recognized for leadership strategies, building relationships, and planning useful digital finance solutions for financial inclusion providers, and dedicated to efficiency, entrepreneurship, and long-term results. He is a senior consultant with Kyrios Dougan Inc. He serves as an advisor to a number of fintechs and startups with the responsibility of ensuring best practice approach and developing frictionless user experience models in digital channels. Welcome, Mr. Dougan, and I would start off with our first question to you, which is the emergence of the fintech industry and its compliance with AML. What are your views on that at this point?
Let me start off by saying I think we in the fintech industry do find our regulator, the BOG, very proactive and progressive. Before even this AML law came into, was passed and assented, we were operating under what was called the payments guidelines. So really, if you look, and this was even before what is now known as the Payments Act, the Payment Services Act, right? So we in the industry abided by those guidelines. There was no, as you can say, act or law that stipulated what we had to do. A set of guidelines was issued by the central bank, and a lot of us abided by it. So we're very comfortable with our regulator. We find it a positive step, and if you look at it, really, the national AML policy, which was again enforced or brought into action somewhere in 2019, did have some positive impact, you know, on both the industry and as the country as a whole. Between 2012 2019, Ghana had an AML index of about 5.3 thereabouts, and we're ranked 53 out of 140 countries. In July, even before the act, but then the policy had been issued. In July 2020, our index improved to 4.8, and our position changed to 85, which is very good. So you see that not only were the steps taken in 2020, but a whole policy, when you have a whole policy in place and there are actions taken which culminate in the act, then you do have some of these, you know, good press for us. At the end of the day, of approved and registered payment service providers at various levels, from EMI to standard to enhanced service providers, has been released. It means that all these firms abide by the law, abide by the rule of law. And again, this is just a side, but if you look at it, some of the news about Twitter, we believe Twitter and even Google having their Africa office in Ghana, does have some bearing on the index that we are positioning on the AML index. You know, it's both causative and resultant in that it will and can attract more global tech companies to come here. At the end of the day, they're also looking for partnerships. So by us in the industry also abiding by these rules and regulations, again, we become ourselves attractive to the global world and tech industry. Obviously, now another consequence of having a low AML rating could be found in when a couple of years ago there was an issue of, I think we all heard it, and some of us were a bit upset about it, that there was news about Ghana being blacklisted by the AU. Now, some of the effects that means is obviously there's a higher withholding tax when payments are being made cross-border. You know, so when it comes to remittances, for example, or which tech firms are fintechs are quite involved, payments into Ghana would be held by the host country due to the risk factor and rating, you know, and a higher portion of those amounts would be held as withholding tax against us. Obviously, again, this has effects on direct inflows. It has effects on remittance amounts coming in. And let me give you an example. We've all heard of ZPay recently acquiring a fintech in Zambia. If Ghana had a very bad AML ranking, I'm sure you can imagine some of the hurdles that ZPay would have had to overcome in this regard. So for us in the fintech industry, we do welcome this. We're quite comfortable. Like I said, we started with guidelines. We've abided by it before the enactment of the act itself, the AML Act. We have the Payments Act, and also the BOG has issued what's called the crowdfunding policy, which relates to basically how people raise funds for donations. Let's say donation funds, which we will and we should abide by, because in the recent past there was some incidences where that was an avenue for some people to channel the AML proceeds. Let me clarify that further. Suddenly, some years ago, suddenly there was a rush, sudden explosion in non-profits establishing in Ghana, and they all claim to have partners abroad outside Ghana, and they were raising funds and received donations for their non-profit activities. Now, everybody knows any serious non-profit organization which operates and does have serious partners abroad will definitely have a bank account. So when someone comes and says we're a non-profit and we're expecting huge sums, sometimes in the thousands of dollars, being donated by people, both individuals and businesses, to us, but yet you don't have a bank account here and you want the money terminated in a mobile wallet, straight away that should raise some alarm bells and red flags. So what we did was straight away we recognized this, and a lot of us, refused to work with such organizations that claimed to be not non-profit. Again, let me say, even before then, before our operations and the act being passed, the fintechs did go through some training on AML in conjunction with the BOG. So we've had that collaboration partnership with our regulator all these years. They've approached us. We've had several stakeholder engagements with them where they take us through what is required of us. Back then, whether it was guidelines, policies, regulations, they handheld us, took us through. And now that the act is in place, it's more of, if you can say, a graduation of our learning, rather than it being imposed on us. So we're quite comfortable with it, and we welcome it.
What would you say has been the impact of money laundering issues on fintechs?
Well, there hasn't been any major impact. Like I said, there were some who tried to use fintechs as a money laundering channel, where they would suddenly come up and say they were non-profit, so we're expecting donations. Now, obviously, from outside, this will be card-based payments, whether credit or debit cards. And again, the question was, why would a non-profit, a serious one at that, not have a bank account to terminate the funds, but rather want it in a wallet? Because the practice was, as soon as you push it to the wallet, they'd cash out and probably throw the same away, which was a possibility. Because obviously you also have to keep in mind, like I said, if your instincts and your red flags go up, you have to pay attention to these. There was also some incidents of some persons coming to say, well, they were the local reps for some betting or foreign company in Europe, and wanted local processors to online transactions, these are, and then after a period of say 1 week or 2 weeks, transfer the proceeds back to the European companies. Now, for us who saw this, and obviously our first question was, why would any European company, based in Europe, where there's a very large number of payment processes, name it from IDN to N26 and so on, a lot of them, why would they want a smaller fintech in Ghana to process these transactions, have them settled in a bank account here in Ghana, and then after a while, transfer them back to the transfer fees, SWIFT, and so on, bank charges. Once, and again, like I said, even before now, in our operations, the regulator had communicated with us, been in touch with us, and we had gone through some of these AML trainings. So obviously our red flags were raised. On these two types of incidents. One is a non-profit coming up to say we're expecting funds from abroad, but we don't have a bank account, so push it in a wallet. And the other saying, we're representing a company abroad, process it for us, and then afterwards transfer it back to the account abroad. Straight away, when these, you hear of these things, like I'm saying, once we've had that sort of training, our red flags went up. So we refused to work with them. So I don't have any major significant incidents of money laundering. There are attempts, yes, obviously, and for those who don't work with the regulator, BOG as it is, could fall into these traps. I'm sure that maybe some of the smaller fintechs may have experiences, but the incidents, I must say, are very few and far between. What you'd rather find is rather a lot of the social engineering where people are hoodwinked into making some payments and then getting. But in terms of money laundering, it's being kept pretty low.
So at this point in time, from what you've explained to us, it sounds to me as if you do not consider that the new act is going to create any significant new challenges for the industry.
No, not significant. No.
That's good.
We've worked with them. We've worked with them. So those of us who've been in industry for a number of years already are alert about these things, and we welcome it. It's more of an improvement of the previous regime, AML regime, policy, if I can put it that way. And like you said, it aims and steps at improving or plugging the loopholes in the previous policy.
Great. So at this point, thank you, Kojo. And thank you for that summary, giving us a perspective of the fintech space. At this point, are there any questions from attendees on what Kojo has presented to us? You may type your questions in the question and answer section, and we will read out your question for him to respond.
Let me add that, you see,
yeah.
I don't think the AML Act itself operates in isolation. It works together with for fintechs, it works together with the crowdfunding policy. It works with the Payments Act, which enforces all PSPs, payment service providers, first of all, to be registered businesses. And there are obviously rules and regulations around that. The registration, capital, board governance, operations, how you operate, security around your operations. So all these come together to make sure that, because anybody who's in want to lose your board wouldn't want to be listed. And believe me, a lot of fintechs are looking for global opportunities, be it across the sub-region, on the continent, and out of Africa. We've heard of the likes of Paystack and Okra and Flutterwave receiving huge investments. We want the same here in this country. Otherwise, we will just be spectators on the fintech scene, you know. And so serious fintechs who have you know their telescopes open and looking at, listen, we want also these kind of partnerships from the big tech companies, who definitely say we need to keep ourselves in check, you know. So it's a combination of all these acts and policies, like say the AML Act, the crowdfunding policy, the Payment Service Act, all these together help us to keep in line.
I think the key thing being that in all of this, for payment service providers that need to be licensed by the Bank of Ghana, for instance, there is that requirement to ensure that you have an AML policy. Now, what such institutions must be aware of is that under the new act, just ticking that you have a policy and putting it in a cupboard somewhere or online in your company is not sufficient enough. You need to follow through with the provisions of the policy, especially with your KYC provisions, to ensure that the situation that you mentioned to us does not recur. So thank you, Kojo, for that. At this point, there haven't been any questions on your presentation at the moment. So if Maame Saah is now ready. Maame Saah, are you okay now?
Yes, I don't know whether I can still share my screen, but I can talk extempo if I'm not able to. So,
okay, give it a try and let's see.
Okay. Please, can you see my screen?
Yes, it's working.
All right. All right, thank you. Yes, I don't know where I got off from, so I'll just start all over again.
Okay.
I wanted us to look at the impact of the new act and the responsibilities that gives accountable institutions as against the previous act that did not criminalize some of the provisions that were in it. So I was saying that basically fraudsters or AML offenders just look at the gaps in our system. So what the new act seeks to do is to make our system more effective, but by ensuring there's a stronger enforcement, and it also helps us or forces us to put in preventive measures, and also make sure that the sanctions that we put in the act are actually functional and effective. So that's some of the reasons why we see more safer sanctions. We see liabilities being passed on to officers, directors, and so on and so forth. Now,
yeah. So may I ask at this point, what are some of the key concerns the Bank of Ghana has regarding mobile money laundering? Sorry.
Money laundering. Okay. So one of the key concerns is customer due diligence, that is KYC. And it is the basis for every customer relationship. And that would also form the basis for an accountable institution knowing what kind of monitoring to institute when it comes to their customers. Determining whether a customer is high, medium, or low risk would help you to know the kind of monitoring system you have to put in place. Identifying customers like PEPs, politically exposed persons, would also help you to know the kind of enhanced due diligence that you have to put in place. And for every customer, I may enter into a system or a relationship with a service provider as a low-risk customer, but as time goes on, people's status change, and I may move from a low to medium customer to becoming a high-risk customer. So we expect accountable institutions to continuously monitor their customers and be able to conduct due diligence on them, and to be able to also enhance and improve their monitoring systems on these customers. So that's one thing that permeates through not only banks, but also e-money issuers like mobile money and also other similar service providers, because it is only when you know your customer that when you put in a transaction monitoring tool, you'll be able to flag suspicious or irregular transactions. But then if you do not know the kind of customer you have, then when you have certain transactions coming through their account, you'll not be able to determine whether this is a suspicious or regular transaction by the KYC that you performed on that customer. So on the screen, you see I have 5 issues. Those are the main pillars of AML compliance that we expect every institution, accountable institution, to have in place. Your internal policies and systems, they should comply with the provisions of the Act and guidelines that we have provided. You should have an AMLRO in place who is not just there by name, but performing his or her relevant function by ensuring that from the board to the staff to independent auditor, everybody is performing their function. The board is trained to be able to supervise the function of the AMLRO and management and staff. The independent auditor is also trained to be able to perform their function properly. So you look at this, and all this is intertwined. When you have all these policies in place, you have adequate employee training for them to know the emerging trends, the relevant provisions, and how they contribute to compliance of the business. It helps. And then if you have customer due diligence in place, updating customer data, updating beneficial ownership data and all that, it helps. So these are our main concerns. And once you have this in place and you are really complying with the provisions, at any time when we have to come in and perform an on-site examination, you realize that you are found compliant, because these are the 5 main pillars that you're expected to adhere to. So our key compliance concerns, as I mentioned, is KYC, ineffective monitoring of customers, and the absence of a risk assessment framework. For this, we expect not only banks, but also fintechs and mobile money operators, all those who have subsidiary, services and products that they roll out. You should have a risk assessment framework that assesses everything to do with your business location, that's your geographical location. If you have a brick and mortar locations, if you do not have brick and mortar locations and you have agencies, you have to take into consideration the geographical location of these agencies in relation to Ghana's National Risk Assessment Policy to determine whether these locations are high, medium, or low risk. And then it would also advise you to know the kind of measures to put in place. So you assess the risk of your geographical location, of your delivery channel, of your product or your service, and then you have that in a policy framework, and it helps you to determine how much how much measures you have to mitigation measures you have to put in place in one particular place or the other. So this is a risk assessment framework is a requirement that we expect all service accountable institutions to have in place, from banks, from e-money issuers and all that. And especially for the fintechs, they usually would present a proposal if they want to have their products or services approved. And we expect that before you bring it, you would have assessed the products, identify the risks, and then also have mitigation measures in place for us to be able to assess and then approve the application for a license. So these are some of the things, and also a transaction monitoring tool. We need it for all accountable institutions. For instance, for the mobile money operators, if you do have this in place and you have a good KYC, anytime you see a wallet holder engaging in all kinds of transactions that are irregular per their KYC, your tool should be able to flag those transactions to enable you to report to the FIC as a suspicious transactions. So these are things that these are main concerns that we expect that accountable institutions will take into consideration when they are, they are operating in their operations. Once you have these things in place, it will really mitigate the risks of AML, of money laundering being undertaken in your space, in your business. So
yeah.
These are some of
Maame Saah, not to interrupt you, but a question has come on as you speak about this, and that how are the institutions able to track online services when there is no location? I mean, how is Bank of Ghana dealing with such situations?
Online services from fintech?
Yes. The fact that there's no specific location. So how do we track what happens?
Okay, so this is where your transaction monitoring tool and your KYC really comes into play. So for that, you may not rely so heavily on the geographical location, but you rely on the KYC framework. That's your customer due diligence. So we are able to track, or the business can be able to track such activities if, for instance, somebody, a wallet holder, brought an identification for a student, and then suddenly you see all kinds of deposits from various wallets hitting that wallet holder's account at every point in time. Then you realize that the wallet that the person is holding is being used for something other than just maybe receipt of allowances, for instance. So if you have a transaction monitoring tool in place, your transaction monitoring tool will flag those transactions, and at the end of your review period, maybe the day, you'll be able to report those transactions to FIC as a suspicious transaction. Because a lot of these money laundering and fraudulent activities that go on online, they usually refer to payments. They ask for payments into some kind of wallet, mobile money wallet, or some kind of e-money issuer wallet. And so flagging it at the end of the service provider would also help investigators to track it. When we pick something like that online and then we get to the service provider, you will see that your monitoring tool has already flagged, and maybe you've already sent information on that to FIC. So it helps to coordinate investigation when it comes to these things. So for the online activities, we do not depend so much on geographical location, but we depend a lot on your KYC and also your transaction monitoring tool that is in place. Thank you.
Great, thank you. So our next question, and something we'd like you to highlight, is in Ghana, what led to us being placed on the list of the FATF, the AML deficiency list? What led us being put on that list, and what must Ghana do to stay off that list?
Okay, so once again, it's not because we didn't have certain things in place. We had all the relevant laws beautifully laid out, but it was difficult to provide evidence that these laws are being enforced effectively. You understand? So we could not provide, we had all the laws and all that, but then when it comes to enforcement, there was not enough evidence to show that the laws that we purport to have are actually being enforced. So that was one of the gaps. And then ICRG, they usually come when we've been placed on monitoring, enhanced monitoring. So they are working with us to resolve gaps that were identified in the last evaluation. But usually what happens is that when they come on site, they look at the documentation that we present as a country, and then they come and sample through sometimes mystery shopping, to sample the system to see whether what we have written is actually what is being practiced. So I think at the last visit, one of the things that they did was to go to a forex bureau to change money, and they were able to do it without any request for identification. And that is a gap. So that is how they pick up the gaps. We send the documentation and they come back and sample the system to see whether we are actually enforcing what we claim to have. So this is where the banks and SDIs come in. The role they have to play is to ensure that not only do they have the policies, but they are implementing the policies in their businesses. It's become a way of life. So you don't wait when Bank of Ghana gives you notice that we'll be coming around maybe in a week or two, then you try to put your house in order, because you do not know when some of these inspectors can walk into yes, your business and sample your service to see whether you are actually complying with the provisions in your act. And we should keep in mind that whatever is in our act is drawn from FATF recommendations, and it's an international requirement. And we are also supposed to play along with the other international players. So these are some of the reasons why we got to where we are. So they identify the deficiencies and they put us on enhanced monitoring. That's how come we got there. And there were certain things that is found also, like our non-profit organization space is not really regulated. Anybody at all can go in there, register an NGO, and then start business. But the source of funding for these NGOs are not really investigated, and we don't have a regulatory body looking into all these things. So when it comes to the KYC of the directorship and of these things, we didn't have a strong regulatory space in that, and we also didn't have
Sorry.
Hello.
As a result of that, not having the regulatory space for NGOs, then the task falls on the banks again, because these NGOs will always open a bank account. So then they would have to do the relevant KYC to catch a suspicious activity.
That is so, and they have also been placed under another regulatory body, which would review their applications and do background checks on directors and all that, source of funding and all that, before they are issued with license at the Registrar General's Department. So that is something that we are also looking at, or is also being resolved. So
does that mean we should stay tuned for some new legislation governing NGOs in particular? Is that what's in the pipeline?
I believe so. I don't think there will be a need for new legislation, we would just have to appoint, and that's what is happening, I think. We are going to appoint a regulatory body to supervise that space. So by guidelines and all that, those guidelines and all that, we are going to be able to assist in that. And so we are also putting together a new law. Okay. It's currently under review at the AG's office, but it's what we are doing now before the new law comes into place is to place them under some kind of supervision to put these things in place.
What is this new law going to cover?
The NGO activities, actually. Okay. Well, there are other areas that have been covered by amendments to laws. For example, the Company Act now has the beneficial ownership aspects in there, and the Registrar General's Department has also amended the way they do their things. So they now have a register of beneficial owners and all that. So we're going to also amend the way the NGOs also operate. That's just one of it. The things that were found not to have too strong on. So these are some of the things. You see those gaps in implementation. We have all the laws and all that, but then when it comes to implementation, the banks already do a good work when it comes to NGOs. They are listed or categorized as high risk entities. So they do an enhanced due diligence on them already. But then we want a stronger regulatory space for them, because when you look at the high risk institutions or businesses, it's one of it. And the other is car dealerships. We have real estate sector and all that. So these ones have also been placed under GRA to monitor. So these are some of the reasons why we found ourselves there. Not because we didn't have the laws, we always have the laws. But when it comes to enforcement, then it's a problem. So we've done a number of things to try and address those issues. Apart from the legislation, we now have a national risk assessment policy. We have a national AML policy. We have enhanced risk-based supervision. So it's not only Bank of Ghana that looks into all this. We have the Securities and Exchange Commission. We have National Insurance Commission. We have other regulatory bodies that also look at the GRA and so on and so forth. And even we have responsibilities for accountants and also for lawyers who handle accounts on behalf of their clients. With your KYC, if somebody is trying to hide transactions through your client's account and all that, you have the responsibility of flagging and reporting such transactions to FIC if you think it is suspicious. So all these are being worked on, and the various bodies, professional bodies, are being sensitized to improve their activities and their outlook when it comes to money laundering. So,
yeah. We have a question for you from an attendee who says that, does the Bank of Ghana conduct on-site visitation on telcos to assess their KYC AML compliance with mobile money transactions?
Yes, the Payment Systems Department does that. And I believe it's even the new requirement for re-registration has come out as a result of collaboration with them, with National Communications Authority and all that. So the Payment Systems Department does that. When it comes to mobile money, they conduct some inspections, yes.
Great. So are there any other points from the BOG's perspective you would want to highlight regarding AML, especially with regard to mobile money and fintechs, just as your general view?
Yes, with regard to mobile money and fintech, I think nationally we are moving towards that direction. So I'll only say that we should ensure first that we have transaction monitoring tools in place that can flag AML suspected activities. And also, we should make sure we take verifiable IDs from our customers when we are onboarding them. And whenever there are third-party transactions, we should also make sure we collect verifiable IDs and put in place a system that would verify these IDs when people are, undertaking these transactions. Currently, I realize that they take your ID and they jot down something. I don't know whether it is verified in real time or they wait at the end of the day and try and go and verify it. So that's something we would have to look at and then improve when it comes to verification of identity, because with money laundering, we may not be able to use the mobile money wallets for much, but with financing of terrorism, it is a possibility. It can be used for a lot of things because you don't need to bring in big amounts. Small amounts may be coming from all over into a particular wallet, and the flow will be consistent, and that can be a means of financing some kind of terrorist activity. So it's really relevant. It's really important that we get the ID verification in place and also get transaction monitoring tools in place to help us to, get off the gray list as we all want us to. Yes. And I think in conclusion, I just want us to also, I want to draw attention to the new provisions when it comes to record keeping, the offenses. Hitherto, we didn't have that criminal aspect of the sanctions, but right now we do have criminal sanctions when even your KYC is not what it should be. So I would really urge banks and SDIs especially to go back and ensure that the KYC they have on record of customers has all the relevant information that is stipulated in the Act. Because when you do not do that, when you are found liable, the punishment is stiffer than what it used to be. And I don't think we want to go there. So let's just take that into consideration. Thank you very much.
Thank you, Maame. I believe there's a question that participant has, who says that it feels like the Act concentrates hugely on financial institutions and fintechs, and there isn't much expectation of big companies who trade in general goods and expect big payments from customers. So what's the position on that? I believe, Kojo, you had a view on this.
So if you look at the new Act, I'm sorry, sorry.
Let's let Maame Saah answer first, and then
Kojo. Yeah, go ahead, Maame.
Okay, so if you look at the new Act, you realize that we now have tax evasion, playing a prominent role in it. So it's also a predicate offense that at first, we just add to all the other offenses, but now has been isolated, possibly because of big companies. And that's the main thing that they do is if they are to fall foul of the law, is mainly with tax evasion and all that. So it's also in a bid to bring into the net more areas of offense. And believe you me, it is not just the financial service providers. We have casinos also being responsible for even those who come in there to even those who want to invest also, and those who come in there to ply their trade and all that. So it's not something that is just skewed towards the financial service providers, but Bank of Ghana is just concentrating on that space because that's the space that we are responsible for. That's why I'm just speaking to that space. the same responsibility goes for the National Insurance Commission, the Securities and Exchanges Commission, the GRE, and they also have systems in place that they are holding people accountable for. And I'm sure that's why the Chief Justice wants to now bring in the tax courts to facilitate these things. So there are things in place, not only just for financial service providers, but for other likely offenders also. So,
yes, and to that, I'd like to also add, before Kojo chips in, that the definition of unlawful activity is now so broad. It includes tax evasion, it includes other general counterfeiting crimes that may fall under unlawful activity. So big corporations who are not in the financial space should not think that they've evaded this law because they are not a financial institution. It doesn't work that way. So to answer Sandra's question, the law is still quite broad enough, given the definition of unlawful activity. Okay, Kojo.
First of all, I think let's give a definition of what money laundering is. Obviously, it's about trying to recycle money in circulation. So if you start from the back, once if any laundered money is in circulation and the person uses it to buy a TV or a vehicle or any consumable, that's part of money laundering in itself. Now, basically, banks and fintechs process payments for the general public. Individuals and companies. If you're a trading company, see your payments, whether salaries or you're paying your suppliers, there's a very high possibility you're either using one of two. You're either using cash or digital means, or a check or mobile money. You're either receiving mobile money or you're sending somebody mobile money, or you're even giving cash out, right? Now, the financial service providers or institutions and fintechs are the intermediaries between basically those channels, right? So you, be it at one end, at the education or at the receiving end, you will find yourself in the loop, so to speak. So no, this does not apply only to fintechs and financial institutions. It's just that we have a significant role to play in ensuring that laundered money does not, the circulation of laundered money is curtailed in the system. Because as a trader, if it's one that you are dealing in, or you've been selling goods to people who've been laundering money, I think there are obviously laws that also could apply to you. So it's not just limited to fintechs and financial.
Yes. And as a follow-up question, I think, Kojo, this falls in your lap. There's a question here from Judith, who says, is it permissible for an organization to use an IP location tracker in an application to detect and mitigate fraudulent transactions because of the mention of geographical location?
Is it permissible? Yes, it is permissible. Listen, as long as you're using a smartphone today, whether you're using an Android or an iPhone, and whether you have, let's say even Google Maps, your position basically is traceable. You can be reached, you can be identified. When you use Uber, Bolt, the shared riding companies, how do you think they get to know where you are? And as you're moving, it shows you where you are, your location or destination. So those things are quite open. Even when you order food, right? The dispatch rider knows where to bring your food to. So you sort of made yourself open, and you've agreed to those terms already, and we
Have we lost Kojo?
I just sometimes
Okay.
layering on top of those services already. To now, as to the extent. Hello. Hello.
Kojo? Yes.
Yes,
You
I'm
were
here.
breaking up earlier, but we can hear you now.
Okay. I don't know where you got me to, but I was saying basically people use tools, phones, apps, and so on, and you've agreed to the terms, and this makes it possible for the originators of those apps to share some details with other third parties who integrate with them. So as long as you're using some geolocation application, you've allowed yourself to be located. Now, as to the extent of use that institutions, I mean, basically the use that is done for geolocations, it will differ and it will vary. The extent could be minimal and it could be even zero at all. But then what comes into play basically is obviously the KYC, and that's done at the beginning of onboarding, both again for financial institutions and for fintechs and for EMIs and for everybody, right? So that some details are taken. And there are guidelines for doing that. For institutions, there are guidelines which we take for the onboarding process, directors and address, office address, key personnel, registration documents. If it's an individual, some form of identification, which must match your name that you provided. And even when it comes to mobile money, there are tiers in the payments level. So you can be a tier 1, tier 2, tier 3, and that is enforced. You can't exceed certain bands in transactions. So all these come together, to help us make sure that we are minimizing that entire risk. And then obviously the geolocation application would be an enhancement, an extra level, an extra layer that we can apply. But the principle is, once you permit it generally in any app, that originator of the app can allow a third party to integrate with it and also utilize it, right?
Yeah.
And I'm saying like the food companies, they don't do the geolocation themselves. They are relying on perhaps Google or some other company to provide your location, okay? And they've integrated into it. Likewise, the transport, the ride-sharing companies, and so on, okay? So that's basically how it works.
And it's good. I mean, if we continue on our current trajectory in Ghana, where we are establishing a Ghana card, which incorporates all our information into one card, and we do actually use the digital address system that we have, I think it will go a long way into curbing and finding these fraudulent persons amongst us. So I think going digital, this act is going to be quite far-reaching, and it will assist immensely. So on that note, we have some other questions, but I think I will ask those questions after our third speaker has spoken. So on that, Godwin, are you ready?
Yes, yeah.
Great. So ladies and gentlemen, let me introduce you to Godwin Kwame Tamakloe. Godwin is a digital financial professional with over 10 years of experience in the mobile money industry and currently the Senior Manager Compliance, AML, and Risk for Mobile Money, MTN Mobile Money Limited. He has worked in fairly diverse markets throughout Africa, the South Pacific, and the Caribbean. Godwin is an avid conference speaker within the Caribbean and the Latin Americas on mobile financial services, microfinance regulations, and compliance in general. He's a certified compliance officer, certified anti-money laundering specialist, associate fraud examiner, and holds a master's degree in operations and supply chain and project management. So ladies and gentlemen, we are really in good hands on this topic with Godwin here as our speaker today. So welcome, Godwin. And I would start off with our first question to you, which is that what are the effects of money laundering issues on mobile money and online transactions? We know how big MTN is here in Ghana and in Africa, and what Momo has done for us. It's been amazing. So what are the effects of money laundering on the industry?
Thank you, and good afternoon to my colleagues and also the participants. In general, as you mentioned, the mobile financial service had, in a way, created, that opportunity for some other businesses to grow. And there is a report by Interpol in June 2020 that indicated that as long as one is connected to the general or the formal financial stream, then there are some kind of vulnerabilities that that person is exposed to. So within the confines of mobile money, currently we have not identified any major ML or even TF issues, but then per our own risk framework, we identify certain risk areas that we know that in case our channels are being used for money laundering or TF activities, then we are going to face those risks. And one of them is the reputation, not only of the business, but also its ripple effect on the country as a whole. And I think our second speaker, Maame, said the same thing about some of the sanctions that we have based on the 1044 as compared to the 874 and the 749 as amended. So yes, we're going to have this kind of reputational risk on us as a business. Then you also have the regulatory sanctions, right? They could repeal your license or administrative sanctions here and there. And I'm very much happy about how detailed the 1044 is vis-a-vis the 749 and also the 874 as amended, in the sense that now we are seeing a very, in quotes, a harsh, punitive actions that will put us on our toes and to ensure that the right thing is done at every point in time within the chain, so that when they come on you, you are much covered. So the regulatory and legal sanction might also come. Then one important thing here is the product risk or the service risk, right? If we get to know, or people get to know, that our channels are being used for money laundering, that alone can cause people to lose confidence in the service. And anytime we talk about money, trust is so critical. To get people on board, trust is very critical. So when people get to lose trust in the service that we provide, then there is an issue. I make reference to 2 years ago, I think 2019, when we had this xenophobic issues in South Africa, and someone did a video placed on social media talking about the fact that MTN, because of what is happening, is going to stop operating in Ghana. And for that reason, the mobile money business was going to stop. It was placed in the social media space on Saturday. By Sunday, it has started causing some kind of panic withdrawals. And by Monday, Tuesday, Wednesday, looking at the total amount of money that was taken out of the platform by fund owners, a total of about 621 million Ghana cedis. Yes, the Monday alone was about 345 million Ghana cedis. On Monday, you can envisage that this happening within the formal banking space where customers are rushing in, trying to take their money off from that bank because they've heard one news or the other. So product risk is very, very critical for us in case there should be something like that within the system where we identify that our service is being used as a channel for money laundering. Then, aside that, is the ripple effect that it will have on the nation, right? Today, the nation itself has an agenda of financial inclusion. And the main channel that is being used today is the mobile financial service. So if that channel now becomes an area for AML or money laundering, then in a way it fights against this agenda to drive a lot of people out of the use of cash into the formal financial area. Then we've all been hearing our vice president talk about a digital agenda. Again, we come to the point that today, as we speak, maybe down the line, we may have various other digital channels playing a very important role in it. But today, as we speak now, it is the mobile financial service that is carrying most of the transactions. And you look at the rollout of the Ghana QR code, and it's also based on the same area. So anything at this point that will be a hit, a kind of a product hit against the service, is going to be something that will have a major ripple effect, not only to the business, but also to the country. Then finally, I'll talk about this could also be a national security issue, right? And I'm saying this because when this panic withdrawal issue happened, I was called to the National Security Office like almost every day. You are there to give update on what is happening, whether everything is okay, there's some calmness, is the trend changing here and there. And so it is a very huge concern for us as a business to ensure that the channels are not used for any ML or TF activities. But as our sister said earlier on, if you look at TF activities, the funds are they just trip in, $1 cedi here, $1 here, £2 here, €3 here. And at the end of the day, it's all consolidated at one point, it's being useful. So that is where our concern is more. Then I made mention of a report that Interpol issued, and they were talking about the growth of illicit drug trafficking using the Eastern and then the Western and the Northern Africa route as the transiting point, right? You look at it as if probably it's just the weakness of the system. That is why these guys have now chosen this route. But on the other hand, something hidden behind is the fact that it could also be that around this same channel is where mobile money is also growing, right? The Eastern corridors, the Western corridors, and also the Northern corridors. So could it be that the growth of mobile money is also in a way indirectly attracting these people to use these channels in both moving the product into Europe or Americas, and then channel the funds back, and within Africa, we have when it comes to the TF, you have the Al-Shabaab, you have the Boko Haram. All those ones are playing into is mobile money gradually creating that space for them to now use this channel. So it is something that we are very, very, as a business, we are very, very serious about to ensure that our channel is not used for ML activities.
Yes, and I'm glad you said this. Hopefully it will assuage the fears of users of mobile money who may think that MTN is being careless and all it thinks about is recovering its monies and its millions. But it's the implications to you as a listed company is even far more dire than the individual's potential risk. Now,
Right.
as we talk about that, I'd like you to let us know what has led to MTN requiring this ID at these service points for the Momo operators. Yes, because this is, this is a big thing for all of us, including myself, about our IDs being out there. So if you could give us some information on that with regard to why it's being done and how protected are we?
Yeah, Maame said something. Pardon me to use the word, to use the name just Maame. Afua, Mrs. Frimpong said something about identification. Basically within the financial sector, and the banks, the bank staff who are participating will tell us that to do any financial transaction, there should be a way that you identify yourself, right, as the owner of the account. So even if today I walk into any banking hall, if I'm doing a deposit, they'll be asking me to do some signing, right? If I'm doing a withdrawal, I may be asked to sign at the same time, give out my ID card for them to go and do a photocopy, right? And you have no idea how many copies, the banks will do or what they use the photocopies for. But we trust that the banks, as they are, will be able to protect our data. So it's the same thing that we are switching into. And when we started the mobile financial service in Ghana in 2009, you realize, if you remember, that we were providing them with, which we still do, with transaction booklets, right? And in that booklet, they do record your phone number, your name, your ID type, the ID number, the transaction type you're coming to do, then the amount. And some of them will give you even the document to sign before they do a transaction. And these were in our booklets, right? But then as time went on, we realized that one of the issues that we were seeing within the fraud typologies that were happening was the fact that we have people who will just hover around where the agent is. And when the agent's mind is off what he's doing a bit, they take a screenshot or they take a picture of the booklet. And then that gives them whatever information they have. Your ID type, your ID number, your name, they could just go and use it to create some fictitious ID and then use it somewhere else. So we looked at that and we started engaging the regulator to see how best we could just transition this from the manual capturing of this information, where I think at this point in time, that is where the worry of the public should have even been, as at that time, where the agents were taking record of those things in the booklet, and how are the agents managing the information captured in those booklets before it even gets to us, right? Because when the book gets finished, we replenish it and then we take the old stock.
So sorry, the agent keeps that book with them until the book gets full.
That's right. That was at the time. So this present one is to migrate or just digitize the process and do away with the recording of the information in a booklet. So you realize that in certain situations where for a reason or two, we are not able to feed the agent or replenish the booklet with the agent within the time, you would then realize that they will use their own foolscap sheets, right? And then they start recording them. And those ones we don't have any control over, because you will not go for him to tell you, this book, I bought it myself and I have all the records in it, so take it. No, they'll just give you your booklet that you give to them. So it was just a way of migrating what we had started and making it more digital. So asking them not to now do any recording of the IDs. Let the person show it, capture the number on the phone as part of the process, and that ends it. So we then have that information directly instead of it being with the agent and then we going for it later on. So that was just the main reason. And then we see fraud issues, people come in using somebody's phone or somebody's wallet, and issues comes up, we need to resolve. So now try to just identify yourself, just like I walk into a banking hall and I've been asked to give out my ID, before a transaction is done. So that's just it.
Yeah, and I think this process you've now adopted works well, because we can have some assurance that once the data is within MTN, MTN has that responsibility to ensure that it is kept safe. The law compels you to do that. And then you have a situation where I don't think, from what you've described, that we're going to have a situation where the mobile money agent is able to duplicate the information that he's entering, because he's at that point in time before the transaction is authorized, he's entering the information into an MTN database directly. So hopefully, with more explanations about how this is being done, I think people will relax some more. So on that point, there's a question here. There are two questions. Adelaide has asked this question. It's quite long-winded, but I'll read it out to you. She says, so as Godwin currently pointed out, we are aware of the latest direction of presenting an identity card for withdrawal of funds. Any of the officers have been accused of assisting in these illegal activities. How can we trust our identity information with the same people who are helping this crime? And can we find other ways to drum up support for PIN to be kept a secret other than opening up more to threats? So I think she's asked two separate questions. I don't know if you can.
I didn't get the first one. He made mention of some
talking about the officers haven't been accused of assisting in the illegal activity of presenting identity cards for withdrawal of funds. So I'm assuming she's talking about the agents, the MTN mobile money agents.
Oh, okay.
Yes.
So you realize that we did some kind of post-transaction validation, which is what we are doing now. And I think, again, Maame Frimpong made mention of the fact that they are not too sure how we are handling the process, and they probably want it to be a real time. There were some challenges with the real time at this point in time. So what we are doing is a post-transaction validation. And some of the issuing authorities are also helping us. So when we capture the information, we share the IDs, and then they respond to us within 72 hours. And we are able to do our own analysis of what we have. And based on that, recently, I think about a week ago, we identified agents who were really, trying to screw the system by inputting, they select a voter ID and they input a number like 111122223333, because we're not doing the real-time validation of those, cards. And because the transaction went through, they thought, that was it. So the background post-transaction validation gave us a fair view of those agents who were trying to go around the system, right? And we blocked about 7,800 agents' wallets. At this point in time, as I speak, those agents' wallets are still blocked, and it is supposed to be blocked for 1 month. And that is just the first warning. And anyone who we see, again, from our reports, who is doing it for the second time, then we have that person's contract terminated, and then the legal guys will advise us if it is something that is prosecutable, then we take that agent on. So there is some punitive action against those who want to go around the system at this point in time, and we continue to do the validation, and then we'll come up with those that have faulted. But in general, if you look at the first 2 weeks after the implementation, we had a total of about 250,000 agents who did transactions, at least one transaction within the period. And out of the 250, we are blocking 7,000 liters. So it's just about 3% of the agent base who, were trying to, go around the system. So we confidently can say that our engagement with the agents and other stakeholders have helped that at least seeing that most of the agents are doing the right thing. But I mean, there's no system that is perfect. And so we'll see some of them trying to go around the system where our own customers sometimes encourages, the agent to do same. So we'll do what we can to ensure that agents, comply.
Yeah, like saying that, oh, this is my grandmother and she doesn't have an ID. Please do what you can. She needs her money. So we ourselves encourage the non-compliance.
That's right. That's right.
Okay. So further questions. I think questions are really dropping in now for you, Godwin. So I'll proceed to give you the questions. Gabriel asks, to what extent are the ID card presented at the mobile money point verified? There may be incidents of presentation of expired IDs of other people for the transactions. Gabriel, I think Godwin has just answered that we are going to get to a point where there'll be real-time authentication of IDs. So at this point in time, the authentication of IDs as presented is done, you mentioned, within 72 hours, Godwin?
Yes,
those within 72 hours. So
yeah,
if someone has presented invalid ID within 72 hours, there'll be either a blocking of the account or the agent's account is blocked. So some step is being done, and going forward, MTN intends to do a live authentication. So the system is going to get better. Yeah.
Let me, if I may just add something. People had a concern, and it's a fair concern, that why didn't we right from the beginning just do the real time, right? And the issue we had with the real time were two main things. One was our ability to connect to the third party, database, which is GVibe, and the GVibe should respond to our database when a transaction is ongoing. Most of our customers are using the USSD as compared to the mobile application. And the USSD session is just about 60 seconds or 80 seconds, right? So if there is any delay between the ID validation database against the transactional platform, then it's going to truncate the service. And so what we saw is that we might end up having a lot of people not being able to do a transaction because of that latency.
Transactions, yeah.
Exactly. Then again, you also have the situation where it's not all the IDs that are in the GVibe database that we currently are connected to. Some of them we have to, go to the issuing authorities, and that is where we have the 72 hours. So at the end of the day, we harvest the information we have, and then we send it to the issuing authority, and then they help us within 72 hours. So we realize that the real time at this point in time with this kind of challenges wouldn't be something that we'd be able to do. So we are doing the post validation of the IDs, but efforts are being made to ensure that we will be able to go and do the real life validation of IDs.
Yes, and I think I've had like a light bulb moment with what you've explained, because there's so many people who are using mobile money. And I'm one of the people who is complaining about government requesting this Ghana card when we have TIN numbers. But if you think about that, we have what NHIS cards we are presenting, people have SNIT cards, we have voters ID, we have passports. So if we can put all of these, amalgamate them into one system, and imagine MTN has access to that database, then in real time, you will indeed be able to confirm that that is a valid ID, compared to the situation where we are scrambling about to different institutions to confirm whether the person indeed does exist. So thank you, Godwin, for that. We have another question here. Does MTN conduct background checks on these agents before onboarding them? And will MTN accept any form of liability when an agent uses a customer's information for other illegal purposes?
All right. As part of our onboarding process, there are some that we consider high risk, and those are those that will go to that extent of doing a criminal check on them. We work with the police, and then they help us with those criminal checks. But one thing we need to also understand is that the current database we have in Ghana for criminal checks, if you've not been convicted before, your name is not there. So even if you have committed any fraud, right, or anything at all, you've been arrested and taken to court, and you were not convicted, your name is not there. So our view of criminal check within the Ghanaian context is just limited to those that have been convicted before. And so you have a lot of these agents, because they are not convicted before, any other thing that they've done that at least would have flagged that this, you need to take a second look at this particular person, is something that you don't know, but because the criminal check record will come and is clean.
It will be clean.
Exactly. But then the next step is the ongoing due diligence, right? The transaction monitoring. Those ones are the things that also help us. And some of our banks, I have been working with some of our banks, I don't want to mention names, in trying as much as possible to understand the work that these people do, so that as time goes on, you are able to reprofile them, and then you know how these people are within your framework. So yes, we do checks as and when we are supposed to. What was the second question?
I think that's it for that one. And then the next question says, how are telcos able to pick intelligence on agents who might be involved in ML? I think you just answered that. But if you could expand on how you're able to pick up these fraudulent agents.
All right. So the mobile money is not telcos. We are a different breed of of people. But our mothers are the telcos. So in that sense, we do have, just like the banks, right? We do have a system that does the monitoring of transactions. Also for us, because of our access to the network, it is easy for you to see geographical location or have a fair view of where a particular transaction is emanating from, where this agent is located, the kind of transaction it does. You'll be able to understand the corridor of the transaction that particular agent does. So this, in a way, helps us to know what the agent is doing. Aside that, we also have people on the ground. And let me say this, that when we went out with this directive, we had over 1,300 people that we asked to just go and do mystery shopping, which were being paid by the business. So we do have people on the ground who also pick information and then share with us. And based on that, we also take, take action. And then our own banks, especially with the agents, we encourage them to connect their mobile money wallet and the banks, their bank account. And so some of the transactions they do, if it is hitting any red flags at the bank side, they would also just raise a flag on our side. And then we work together to see how we can, reprofile, or if we need to report to the FIC, then we do that.
Okay. And an attendee is asking that there used to be an advert that introduced MTN to the world called Mensaka. So is it possible for MTN to take the same path of an advertisement because he or she believes that the general public can grasp this concept better than the current advertisement that you have, which is don't be a mugu? So perhaps localize your advertisement on this a bit more.
That's well noted. That's well noted. We'll just we'll share that. We'll share that at the start of the service. What we're trying to do is to create the buzz and also create the awareness of the presence of that service within our communities. And so the Mensa account really did what it's supposed to do. People just got to know about it. But then there were some other things that were done later on to now kick in the customer, moving in from being aware of the product and having knowledge of it itself and using it to become an active customer. So it's taken on board. Yeah.
Okay. And then Maame Saah, I believe this question is for you. It says from Stephanie, how often should firms be conducting their compliance monitoring review to ensure their policies are not dormant? You're on mute, Maame Saah.
Sorry. And so some, it's an internal thing. Some do it once a year, some do it once every 2 years. But what accountable institutions should take note of is that you take note of the new laws or directives or guidelines that are in your space as a compliance person, and you ensure that you update your manual, your policy documents for your board to review and approve. So how often you do it is entirely up to you, but you also always have to make sure that it complies with the relevant laws that are in place at any point in time. So sometimes the act comes in place and then we do the regulations, we issue guidelines, we issue directives, and you have to always to make sure that you are abreast with all those relevant compliance legislation. So that's
okay. And then
if I may add, I would
yes.
rather, I would say, just in addition to what you said, as and when need be, right? As and when the need, so it means you, as the AI, the accountable institution, should be abreast with the trends of, for example, your own services that you are launching. You can come in, innovation today is everywhere. You can come in with a new service that might need you to adjust your policies in line with the AML Act or some other regulations or policies that are being issued by the regulator. And so I would say, as and when need be, you need to do it.
Yeah. And then Godwin, the next question is for you. Does MTN file any suspicious transaction reports with the FIC? If yes, through what platform? I'm wondering why this person wants to know how you file it.
This, I love it. I love that question. Probably the person is from FIC. This is a very huge burden for me as an individual. And maybe Maame will take this one up for us. I'll be very grateful. The point is that I've had instances of being in workshops organized by Stability and realize that the content of the workshop is just towards the banks, right? The mobile financial service operators becomes afterthoughts. So today, if I am reporting, I need to report through the FinTech and Innovation Office, and I'm not too sure whether what we report in terms of STRs gets to FIC. Direct FIC, we have made several efforts indicating to them that we don't have access to them. In sharing, we need to share some of this within 24 hours per the Act. Unfortunately, some way, somehow, we are not able to get to them. So we have to go through Office of FinTech and Innovation. And so this I believe the person probably is from FIC, and I'll be grateful. We address this issue, giving us that direct contact with FIC, having a way to them that we report. As for the BOG, from the payment system to the new we report to them all the time. So I don't have a problem with that. But if you look at the act, vis-a-vis what we are doing in terms of STR, you say that we are doing the wrong thing because we don't report. Our report doesn't go to the FIC, but it's coming to a different department, and that's an issue for me.
Okay. To add to that, I can take that up internally.
Yeah. To add to what Godwin is saying, I'll say that legally, we are not the recipients of STRs, and even when we go on site, we don't look at the details of it because we are not supposed to be privy to that information. So we do whatever we can to ensure that you take it to the rightful recipients so that you not be in breach of the law, because you don't know whether the international assessors will pick mobile money and say they want to see your STR report, evidence of it to FIC. So I think it's something that we have to work on as soon as possible to resolve.
Thank you.
So we'll look at that.
Okay. I think we have exhausted the questions. Okay, Gabriel had asked an earlier question, but I believe it's been answered. He asked, how can we also prevent or avoid possible case of agents using an ID number in their system to process other fraudulent transactions without the knowledge of the original ID owner? I believe as the information is being entered immediately into the MTN database, there isn't room to do that unless the agent is very sophisticated and already has cloned his telephone, so that every information he inputs, perhaps his phone records it. I don't know if that's possible from Kojo's perspective or Godwin's perspective.
I don't even think there's something like an agent system. The agents really don't have any database for the mobile money transactions, right? Everything that is the front end that they are using is just the front end of the mobile money database that is being managed by MTN and MobileMoney Limited, right? So you have an issue when maybe the agent decide to now write the ID details on a foolscap sheet or a limback book before entering it into the phone. Then you know he's also capturing it in records of hand. So there you have a problem. But other than that, you are there, you see it entering, you just have to show it or put it on the table. He enters it, you take your thing away. And I don't think there will be much of an issue in that sense.
And I guess the key is to ensure that they don't walk away with your ID card.
That's
Let
right.
the transaction happen in front of you. But the question I have is the phones that the agents use, is that phone and the phone issued by MTN? Or is their personal phone?
Some of them were phones that we gave out to the agents. Some of them, not just, this will be just about 20-25% of our agents, just to encourage. Those ones are basically, when we look at areas where we really need the presence of agents to serve our customers and we don't have them, then all agents we bring on board, we just give them phones to incentivize them, to be part of the ecosystem. But generally, an agent will have to buy his own phone.
And then I think this is going to be our final question. Maame Saah, that's to you. Nana is asking that we would agree that technological complexity makes identifying and reporting any suspicious transactions by financial institutions a priority. And his question is, how well equipped and trained are these persons who have to do the reporting and the detection? Maame, you're on mute.
Yes, just the responsibility to train compliance managers is the sole responsibility of the business operator. But what we do as a regulator is to, from time to time, organize training for the AML reporting officers, as to how to go about their duties. And I mean, we don't only do that for just the AMLROs, we also do it for staff and sometimes for management upon request. So you would find out that with the banks and SDIs, a lot of them are certified anti-money laundering experts with international certification, and they are well versed in their duties. And they also occupy managerial positions. They are not just any officers, and they relate directly with the board. So most AMLROs are very competent, and by their very level in the managerial position or structure, they are also very responsible people. And whenever they have challenges in their work, they have relationship officers in the bank that they can contact for any assistance. And if we have to link them up to FIC, we do that, especially in the financial stability department. So they know what they're about. And whenever there's a new trend as to reporting, FIC and the Financial Stability Department, that's the Bank of Ghana, we usually organize workshops and trainings for them before we roll out any new software or anything like that. So they are competent in what they do. And we also have the opportunity to contact us for any assistance when it is required. So, thank you.
Okay. So thank you to all our panelists. I think we've gone past 7 minutes past our scheduled time. So I'd like to summarize, and let me wear my glasses to read what I have written myself. So to summarize what we've discussed here today, there's going to be more enforcement of the laws going forward to ensure that Ghana does not fall foul of getting on that list again, because we do have the laws now. The law is more detailed now. And so the ball is in Bank of Ghana's court and the FIC to ensure there's monitoring so that they can enforce the rules. Going forward, NGOs are going to be regulated, and we need to look forward to that legislation to cover NGOs, and there'll be a regulatory body set up for that, hopefully going forward, not in the too far future. And then fintechs, from Mr. Dougan's perspective, the fintechs welcome this new legislation. It really, from what he's told us today, doesn't make much of a difference to the fintechs, because they ideally have been compliant under the old legislation. So they will continue to do so. The fintechs are comfortable, I believe so at this point. And the law does not only apply to financial institutions, and that's a key takeaway. So people shouldn't think that the Anti-Money Laundering Act is only applicable to mobile money operators or banks. It applies across board. So you just need to ensure that you do not fall into any of those unlawful activities and then get yourself under being in breach of this legislation. And then with regard to mobile money, especially MTN mobile money, well, all the mobile money transactions really, the provision of your ID information is really to help us all as individuals. The more information that the mobile money operators take from us will ensure that eventually we all get comfortable with the system, because we will then know that, especially if the live verification exercise does come live across all the mobile companies. Imagine what a perfect world it would be if you can determine that this ID is so unique to whoever is in the Borno Hafo region or at Cape 3 Points. It doesn't matter where you are. The instant you enter your ID number, they can confirm that it is valid or it is a fake number. So let's welcome the digital era that we're in here in Ghana. And then with regard to compliance, for banks and all financial institutions and even corporate bodies generally who are not in finance, just follow through with your compliance processes often. Do not wait for new directive or new laws to be passed. We are all aware of the fast-paced nature of digital transactions these days. So internally, all corporate bodies should take active steps to get more information on their customers and ensure that they look at transactions with a wide open eye, so we don't fall foul of the AML Act. And that applies to us lawyers as well. When our clients bring money into that client's account, please ensure that you are doing some double checks on where that money is coming from. And if you're not sure, you may have to just report the transaction. So on that note, I'd like to say thank you to all our panelists and to the wonderful audience. There have been on average about 70 people on this call, on this webinar at any given point in time, and that's fantastic. Kojo, you have a raised hand.
Yes, just one last insertion, just to add, to summarize. Basically, so, okay, my background is really in banking economics. Yes, my love for technology has taken over. But in economics, there's what is known as Goodhart's law. And to paraphrase, what it says is any legislation or policy or rule that has the ability or becomes a target in itself is itself a bad measure. And it's advisable that you don't even take that step, or you take steps to make sure that you're dealing with every angle. Now, in every policy, basically there are three protagonists or principles you have to deal with: the people, the process, and the intended outcome. Right? Policies can remain. They can. I mean, for a long time. Obviously, you need to be dynamic. This current act is an improvement on the previous one, so which shows that basically the process has been reviewed. Again, you need to look at all the people involved. So on the question of whether it's for only financial institutions or fintechs, again, no, it's for everybody. Because when Ghana is blacklisted, it impacts on everybody from top to bottom. When countries outside increase withholding tax on inward remittances, it will affect everybody because we'll start receiving less than we should. So be it on policies on cash outs for this, like ID and AML, whatever policy that we are looking at, everybody should see themselves as an active participant, because again, it does impact the entire country. But we should always be in a position of reviewing the processes. That's the key thing. The intended outcome, yes, it will always be there. But as long as we're reviewing the processes, then also that impacts on the outcome we achieve, because it's the world is that. Dynamic. It's always changing, these days. And so that's just my thing that's been done in the past few years. We should always be reviewing the processes, make sure that we're working hard to improve it, so that we are ready, we're ahead of the curve. This applies to both the regulator, the fintechs, the players, everyone, individuals, institutions, traders, everybody.
Okay, thank you for that concluding remark, Kojo. So Godwin, do you have any concluding remark for us?
Just to say that it's good to have the Act 1044, as you and Maame just talked about, very extensive and detailed, covers a lot of things. But I think that there will be the need for us to now move from the policies and then see how its implementation and how effective it will be on the ground, right? As she gave an example of the auditors going to a forest bureau, so if that implementation of whatever is in the act and the oversight of it is not done properly, then we'll just be going around the circles and probably might not be able to move out from where we want to move to where we want to get to. So we'll still need the regulator to be close to us, work together with us from where I sit, so that we move away from the police and the suspects more to stakeholders who have same interest in what we are. That's just what I would say.
Okay. And Maame, your concluding remark?
Yeah, to add to all that my co-panelists have said, I think this is an opportunity to bring together industry players and regulators in a way that we can collaborate to ensure that we enforce the law to our mutual benefit. So going forward, if anybody, any bank, any SDI, any e-money issue has any problem or any question, they shouldn't hesitate to come to either the Financial Stability Department of the Bank of Ghana or the FinTech and Innovation Office and engage us, and we are ever ready to help you ensure that you enforce the legal requirements. And our joy will not be to bring a stick chasing after, accountable institutions all the time, but our joy will be partnering with you to ensure compliance for our mutual benefits. So thank you very much.
Thank you. Thank you very much to all our panelists. And finally, I'd like to say a very big thank you to all attendees for being on this webinar. Your presence has been greatly appreciated, and I do hope that you have gained some knowledge and you have found this webinar useful. For a Friday at 2 to 4, I know that's the time everybody is trying to get home, so to spend your time with us is greatly appreciated. So on that note, Koranteng Koranteng Legal Advisors would like to say a very big thank you again. We are a corporate and commercial law firm based here in Accra. Our offices are in East Legon, and we look forward to having you once again in a subsequent webinar. There'll be a survey that goes out to you attendees later, and perhaps you can indicate to us what other subjects or perhaps what other kind of formatting you would like to see this webinar in. Due to COVID, we can't have full-time in-person conferences. So until further notice, we'll have to make do with these webinars for a while. So you may contact us via our website address, which is www.korantenglaw.com, or via social media handles. We're on social media, or send an email to info@korantenglaw.com. So thank you, everyone, and have a wonderful weekend. Thank you for being you. Stay safe. Bye-bye.
Bye. Ciao, everyone.